Are you facing a narcissist in divorce? And have you ever heard of Brandolini's law? Today, we're going to be talking about 7 things that are going to help you based off this Brandolini's law when facing a narcissist in divorce, mediation, court, or just going through back and forth trying to decide what's what when it comes to property settlement and children's custody. Hi, Mum.
Hello, Laura. How are you? Happy New Year.
Happy New Year to everybody, and Happy New Year to you, Mum.
Thank you.
I hope everyone got through what they needed to get through. And the best thing about 2025 is it always feels like a new start. Let's see what this year can open to us. And I know the people that are currently halfway through mid-divorce drama, you may be thinking, oh, this is another year of hell. But you never know what might happen later on this year. So my fingers are crossed for you, and Mum, yours are too.
Yep.
And I think this episode is going to be really helpful for anyone who's got a manipulative or controlling or a narcissistic type ex, or even just knowing about these if your ex is always making stuff up about you.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So, Mum, I'm just going to quickly do a little summary of Brandolini's law. I accidentally stumbled across it.
He sent it to me without any context, and I looked at it and I immediately thought, is this Brad Pitt and Angelina Jolie?
No, no, it's not.
Then I read it and I thought, maybe.
Oh, let's not get sued. Okay. No, it's not. So I came across it when I was doing the doom scrolling at midnight on, I don't know, sometime during the holidays. And Brandolini's law was actually created by an Italian computer programmer. And he noticed that when people were spreading false information on the internet, it kind of just caught like wildfire and would just spread through the internet like crazy. And he realized that there's a disproportionate amount of effort that it takes to disprove these falsehoods compared to how easy it is to make them. And I realized, I was like, wait a minute, I had an epiphany.
Absolutely.
And I went, wait a minute, this doesn't just apply to people making up stuff on the internet. This applies to those horrible exes who just make random stuff up about you. And so it really does help when it comes to dealing with narcissistic legal letters, mediation, court. And we want to give you 7 things to help you through this. So I'm just going to quickly tell you the exact law, and I'm not going to use the swear word because there's a swear word in this exact law. It is the amount of energy needed to refute BS is an order of magnitude larger than it is to produce it. So basically it's saying it's so much easier to make stuff up than it is to disprove it. And Mum, you must get that when you've had clients where they get this letter or an affidavit and they just go, what?
Yes, absolutely. And if it's a lot of rubbish in it and a lot of it's untrue, they become really overwhelmed in terms of refuting it. And we used to say something not as well, I guess, but we used to say that some things were very easy to allege, but really hard to disprove. And I think that's always been the case in family law, particularly, where people do want to tell big fat lies. Because if you're a commercial law, there are documents and business records. But in a marriage, behind closed doors, your word against theirs.
So understanding this is going to help you prepare mentally and emotionally for the toll that you may need to pay to navigate this. But we're going to give you 7 things. And I guess the first one, Mum, is you really just have to steel yourself to not be shocked, because narcissists are experts at making up these things and twisting the facts to fit their narrative. You know, they're going to make lies up on the spot without hesitation. They're going to make it hard for you to respond in real time. And they're really skilled at making false things with half-truths.
Yeah.
So, Mum, do you think that steeling yourself to know that's coming does help people get a better footing in mediation or court?
Yes.
or just in divorce in general?
Yeah, I think being aware that might happen, and also prepare yourself for the most outrageous reversals of roles. Years ago, I had a fellow who had claimed back the repayments book for something. It required it to come back, and then photocopied it and attached it to the affidavit and said they'd made all of those payments that had actually been made by the other person. Like they just and people like this will look you in the eye and tell you an absolute lie. So if you remember that narcissists always lie, then that will help. And they may like revert or reverse things, accuse you of things they did and take the glory for things you did.
So whatever happened in your marriage, any bad things, just assume they're going to say you did it, even if they did it. So just get yourself prepared for this is going to be a nasty fight. And if this person lies about everything else, they're going to lie about this. So don't be shocked, because that's what they want. They want to get your reaction. So the second thing that we want to remind you all is to use your energy wisely, because like Brandolini's law says, refuting these lies is going to take more energy than it did for your ex to make them. So each false claim is going to take effort, emotional energy to disprove, sorting through paperwork. You're going to literally be highly stressed all the time. And I feel like a lot of people who do listen to us who are going through this post-separation abuse knows that. And we have done an episode called Word Salad.
Yes.
And we talk about how to go through it and how to sift out all the crap and so if you are facing that and you are feeling like you're wasting your energy all the time, then go and listen to that. But you are going to have to use your energy wisely when it comes to this, Mum.
Yes.
Can you explain a little bit about the word salad and why, unfortunately, in law, we have to refute these claims?
Yeah. Okay, so the word salady thing was that you go through, take out all the emotional words just listen to our program on that, and then you get to the nub of the allegation. And then, of course, if you just say no, then it maybe neutralizes it, but it doesn't prove that they're a liar. And if you've got the evidence, find it, collate it, and you've got it then to prove that they're wrong. The problem I'm seeing in law is that the Evidence Act says if you don't deny an allegation, if you don't specifically deny it, then you're taken to have accepted that as true. It's like really awful. But you can do kind of blanket denials as well. And that you just say, look, if I haven't addressed anything in this, it's because I haven't got space, but I deny those allegations,
So I guess when choosing to use your energy wisely, because if you are in this post-separation abuse battle, and we do hear of people who are in the system for 5 years, 7 years, 2 years, you name it, you are going to need to have some breaks, and you're going to need to put your war helmet on and get typing and searching and then have another break. But you don't want to be always in that refute mode.
Yes.
Now, basically, the Brandolini's law, he was basically saying, there's no point wasting your time on trying to refute those, because there'll always be more. So it's better off educating and trying to show that person who's written it is a liar or whatever. Now, obviously, like we said, it doesn't work exactly for family law, but it does explain why so many people are so exhausted, which comes to the number 3, which is narcissists know that it's going to use your energy up. They know emotionally and just organizationally, just writing stuff is going to make you exhausted. So they use that to their advantage. And that's post-separation abuse. And they're hoping you're going to give up because it's so time-consuming.
Yes. And, of course, the more of these allegations that they make, the more letters if you've got a lawyer, that your lawyer has to read and address with you. So that's more money and more time and more delays. So they're not playing really with a straight bat. Their aim is to not to get to the end and get a resolution and move on. Their aim is either to keep you in a spin cycle, and they know the words that will really set you off, and they do that. And then their other strategy is to delay the whole thing so that you give up and they get a better outcome. You do have to conserve your energy.
So not giving up is a huge thing. And we see so many people, and I know you say this, Mum, and it makes people so sad. But sometimes with these types of people, and we're going to talk about trials later, you have to kind of keep going to get to the trial for the truth to come out. And you need your energy to get there. And those narcissistic legal abuse kind of people, they know they can just kind of keep you busy and stressed, and you'll just give up and then they'll walk away. But if they get in the witness box, Mum, boom.
They get their comeuppance. Yes. So I don't always think it's a good idea. If someone makes an allegation, you can deny the allegation. Sometimes you can deny it with proof if you can find it. Then they'll go on to a different allegation and you're like hammering nails down. But sometimes just denying it and saying to them that, this isn't right. And then at the end, maybe under cross-examination, they might break down, or a new witness might be able to give the evidence on your side. So there's a really interesting balance between your obligation to show all of your documents and the benefit to you of showing your hand to the other person so that they can make up a cock and bull story about it so that it doesn't look as bad as it does. But I do think these people, if there's enough of this utter BS, there is an opportunity for them to be revealed in trial. And that's when you most see the good outcomes.
And I want to put this into everyone's minds, Mum, and I've heard you say this to some people on our Q&As, and that if you give them enough rope, even though you might be so disheartened right now, but if you had a very quick court case, and your divorce was over in like 2 months, and you did have this kind of person, you would probably lose really easily because they just have a couple of lies and there's nothing happens. There's no play out. But I guess the positive, and I know no one thinks there's a positive, to those people who are going through these long ones, it's slowly over time, all those lies and all the drama and all the behaviors that they start off looking like they're perfect and then it all kind of slowly unravels, can be a blessing in disguise by the time you get to trial. They're tripping it up. And
so when you go and see a lawyer for the first time, they take your information, right? The other side, he also goes to a lawyer and they take their information. The first letter comes to me, say, as the lawyer for the first client, and I look at it and I go, oh, that's different to what they told me. You get them back in or you ring them up. They clarify it for you and then you can respond. So the first person most people have to convince about these lies is probably their own lawyer. No one else should really be seeing all of this. Once your lawyer goes, I've got it, that's a really good moment for you. But the really joyful moment is when their lawyer works it out that their client's rubbish. And then I guess the triumph is when the judge works it out. But in the meantime, you have to kind of rebut these allegations. But once you've got your lawyer aware of the nastiness, you only have to prove them wrong on one or two things. Then you've got an ally.
So one of the other things they do, because they're constantly making up all of these BS, as the Brandolini's law, always making all this sort of stuff up, is it just becomes piles and piles and piles and piles and piles and piles of subpoenas, affidavits, documents, photographs, you name it. Tip number 4 is don't let it become a battle of distractions. Control the narrative.
Yes.
So, Mum, can you explain how all these false claims can just end up being a distraction tactic?
Well, I've been
and a battle.
The letter comes and it's like mingled with that. How could that person tell such a lie? Is also, how could I be such a bad judge of character that I married this human? And then, so it comes front of mind. It becomes really important, but it's not that urgent. So you're going to have to put it to the back burner. If you say something like a client denies, or I deny all of those allegations, they're absolutely not true, and I will give details later, that sort of thing covers you for denying, but also allows you to hold a space then for later on to deal with the individual ones. So then you want to put your positive case. The court is going to be interested in, say, in children's matters, in competing scenarios. If you spend your whole affidavit or evidence knocking down the other person's proposals, you don't give the judge a choice because you don't show them your side. So you have to make sure you've got things to prove in every case, in property, in children's matters. You've got a point to make. Make sure you make that point. And then really the response to the other material can go at the end. And something like that magic clause about that it's a short hearing at the time, it's a short hearing and on an interim hearing, and that I reserve the right to address those more thoroughly later. Kind of just give the court something that shows you in your light and your truth. You don't have to bash the other side down. You just say they're telling lies.
So I guess you got to kind of imagine for a moment they haven't said anything bad about you and you were dealing with a normal, reasonable, sensible person, and you put your reasonable, sensible proposal forward, because I've seen it so many times, the tactic of just she had a meltdown or they're crazy or this and this. And so that everything they write and everything they say comes through a lens of, but I'm not crazy, when they should just be writing sensible, reasonable scenarios for a judge or, for the other side to consider. So yes, be aware. Don't let it become a battle of distractions, because that sometimes I think, and no offense to the family court or to lawyers or to mediators, but I do sometimes think if there's so much information, it looked like an election when one party is saying this and this and this about someone, and then the other party is saying this and this about someone, and you're just a voter. Can you be bothered to go and look it all up and read it all?
Yep, that's right. What's their policy? One way of dealing with that stuff and not letting it get too much front and center is prepare yourself for it. To, like you said, steel yourself for it. And I think when it comes to, I think you should say to yourself, of course they'd say that. Of course they'd do that. Of course. And that kind of takes the heat out of it, instead of, how could they say that? They know me better than that,
Yeah. Now, like I said, Mum, in the Brandolini's law, they were basically saying there's no point trying to chase this, it'll take more energy to put it down than it is for them to create a new lie. So one of the things that you said was to try and discredit them, or you could get them labelled as an unreliable witness. So can you explain how that could maybe help a lot when it comes to all this nonsense?
Yeah. So the court, often a judge will have two different versions of an event, and there's no way of knowing who's right or wrong. The court can't make a choice usually on that fact, but they can look back and see if someone's they call it whether they're credible, a credible witness, have they been a reliable witness, or have they been an unreliable witness? And then the judge then will say something like, because X was truthful, appeared to be truthful in their responses, I prefer X's evidence on this matter where I don't have any third party thing. And once the court gets it in their heads that this other person is a liar, and they won't do it just by you saying it, you'll have to establish that they're lying, prove it, then the court will then have no hesitation in leaning towards the non-lying, the proper and reliable witness, that you, and discounting the stuff that the other side says. So you think the judges go through this all day, every day. They see this behaviour, and once they pick out someone who's lying, they're very good then at being mathematical about what they accept and what they don't accept.
I guess the downside to that is, however, most people are going to interim hearings or mediations, and that the judge who would pick the liar isn't there, and they're just these random other people that are doing it. And I guess I know they're doing it so they can make the system faster, but I have heard so many people that have gone to these interim hearings and they've proven in the past their ex is a liar, and they've got new applications and more drama, and they just ignore it. And they just
because interim hearings in the FCFCOA hardly ever include oral evidence, and it is in the oral evidence, the giving of evidence and being questioned, cross-examined on that evidence, that the court can decide whether or not someone is a credible witness or not a credible witness. So on an interim basis, no one gets to decide who's lying and who's telling the truth unless there's something third party comes in. So what the court does, they say, we don't make findings of credit on an interim hearing. We'll just find it on whatever the undisputed facts are and evidence from a third party. Those people hold on if you get to trial, the comeuppance will come. But until then, there's a lot of stuff that happens in interim hearings that just doesn't seem fair. But the court will be hopefully with children, child-focused. I think there's a leaning back towards keeping the kids in their status quo. That remains to be seen, whether that happens or not, because that's what used to happen. The court would say, I don't know about the two of you, who says what, who's Wednesday, who's Thursday. But all I know is that when you two were still together, you thought it was a good idea for this person to have most of the time with the kids, or immediately after you separated, you thought this was a good idea, and so they just looked to that. So to be fair, the staff and the judiciary who are handling interim applications can't, because they're quick and easy and there's no cross-examination, they will never make a finding of credit.
Okay.
That is the best they can. Yeah.
So I guess with our tip 6, it's choose your approach based on where you are. So, in court, like Mum just said, there's all these different rules for first mentions, interim hearings, etc. But also, Mum, with the affidavits.
Yes.
What kind of strategies can people have for their first affidavit as opposed to their trial affidavit? Is there a differing approach?
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
What kind of strategies can people have for their first affidavit as opposed to their trial affidavit? Is there a differing approach there?
Because those first affidavits for interim hearings are small. I think it's 10 pages.
10 pages.
And if it's really unfair, thinking about your Brandolini's law, if the other person used their 10 pages making up stuff and throwing mud at you, you'd expect to be allowed to do 10 pages in rebuttal. But if you did, you don't have any time to put your scenario forward. So you're going to have to make sure you focus on your case, like we said, but then perhaps do a blanket rebuttal. In other words, say, I don't agree with the stuff he said from paragraphs 9 to 16.
And just before Mum continues, see a lawyer.
Yes.
Every situation is different. So you definitely go and see a lawyer. This is just kind of what Mum would do in her situation. So so for the first affidavits, that's what you would. Is it different then to deal with that kind of BS lying in a trial affidavit?
Oh, yes. Yes. You take each and every one and detail it and put your proof and have them ready for cross-examination, and you attach your evidence. That's completely different. Okay.
So I guess then I think to anyone who's listening, whether you're at the start, the middle, or close to the end, you should be maybe starting a document and having any lie they've ever made about you, pop it there.
Yes.
And put your evidence.
Yep.
I have heard of people whose lawyers, a week before trial say, have you got any proof about this? Or how many times did that person call that person? Or what happened on the 27th of, December 72? And you're like, what? And those people then have to go and search and look. And that's not giving your case a fair go.
Yeah.
So be your own documenter. Write down the lies every time they make a lie and put the proof there for you so that you can present it when the time comes. So choosing your approach based on where you are, which will help you conserve your energy for when it really matters.
I think that in terms of your evidence, every document you have, you need to have given to the other side. Otherwise, you're not allowed to rely on it in the trial. So make sure you send all of these documents over. You don't necessarily have to pinpoint what they're proof of, but make sure the other side's got it all. And in terms of your interim applications and things that you doing that blanket denial, that overall denial, a judge once told a class that I was in that you were quite entitled to say something like, on an interim, my lawyer has explained to me the nature of an interim application, or I'm aware of the nature of an interim application, because they're normally only 2 hours and of the limited page limit and time available for the court. Accordingly, I've confined this affidavit to rebutting the first urgent things, and I reserve my right to address the others in a later affidavit. And then you can't have a lawyer say to the judge, they didn't rebut it. Look, they didn't say anything when we said this, but you can just have that in there and say, look, and that's picking your battles, isn't it?
That's great. And because the time between your interim and your final hearing, or the time between when you separate and when you do mediation, can be a year, 2 years. So really, these narcissistic types, they're trying to drown you, basically, in distractions and lies. And they're trying to drown the court as well. And trying to drain everyone's energy, basically. So if you can try and stay calm, be as organised as you can with documentation, you will be able to outlast these tactics. But it's a long game, and it's a stamina game, because it is so unfair that people can just run around and say this kind of stuff about anybody. So I'm just going to quickly go through these again, Mum. So number 1, don't be shocked. Okay, lies are easy for narcissists, and the manipulative type, they are really good at taking bits of truth and making it sound so real. Number 2, it's going to take energy to refute their lies, so use your energy wisely. And I guess in that wisely thing, that means as well, you may have refuted it 2 years ago when they first wrote it to a lawyer. You probably will have to refute it again when they write an affidavit. So don't go and use your energy twice finding the evidence. So keep it all together.
Yeah, I like that idea.
Number 3, narcissists are exploiting this. So this is post-separation abuse at its finest, legal, but they want you to give up, or they want you to just collapse in a heap and go back to them, or just give in. That's why you need to reserve your energy and be aware of these games.
And number your money, 4, Laura. I think you need
to be careful. So right.
Yeah, conserve your money if you can, and don't let them drain you at the beginning of your relationship.
Because that definitely can be a tactic. Number 4, don't let it become a battle of distractions. You need to also control the narrative. Number 5, try prove they're a liar. Try and get them discredited or labeled as an unreliable witness in the final trial. That will be so much help for you when you don't have the proof against the lies that they're making. And choose your approach, number 6, based on where you are. So are you right at the start? Are you in an interim hearing? Is this a final trial? Because your energy levels that you need will be different. And then lastly, step number 7, stay focused on the facts, and like Mum said, your case, and document.
Laura, I think we should say something about mediation, because a mediator is not a judge.
Yes.
And so the question often comes up about whether you should be trying to persuade the mediator of your point of view. And it is interesting, because it shouldn't matter to the mediator, but they often do. And so maybe you can have 1 or 2 little bits of evidence just to discredit the other person. Say, look, I've got this, and they've said that. That's all you need to know. And then hopefully then there'll be a bit more reality testing of the other person, and you won't feel so bullied, because sometimes it can feel like the mediator buys into their narrative, and then it's like 2 against 1 or 3 against 1.
That's true. And if it's a shuttle, which I'm guessing if you've got this type of person, you will want to have you in one room, them in another room. You don't know what they're saying to the mediator. So they could be saying all sorts of things about you that you have no idea about. So you're right, Mum. Even though we say that mediators are not a judge, they're just there to be the runaround. They can put pressure on you. But if they understand that person is a big lying person, then they may do less pressuring, because we do hear so many people get a lot of pressure put on them unfairly so.
Yes. I mean, there's this overall thing that mediation and settling in mediation is better than going to court, but people are beginning to feel bullied. So when I was in practice, I would always have at least one firm bit of evidence that I could show to the mediator to knock the other side's credibility, and then you'd get a decent application. What?
That's gold, Mum. You've never said that or that. That's gold. There you go. So I think, look, when I read Brandolini's law about spelling lies or whatever from the internet, I just was like, wow, it's so right. It's so true that it takes way more energy. And that's why so many, like I had a letter from a lady just this week saying she had to go to a hospital for 2 weeks. She had a breakdown.
Oh.
And she is otherwise completely healthy, happy, normal person, but she was just the post-separation abuse was too much for her. And I think that this kind of constant live drama, unless you can really pull yourself down, batten the hatches, and look at it from this kind of approach, it can easily have you chasing your tail and ending up somewhere to get the well-needed rest you deserve. And I know it doesn't make anyone feel better thinking, oh gosh, what am I going to be facing? But there is a chance if you disprove them early on, the lawyer gets wind of their behaviour and they'll pull them into line. But I guess we do hear a lot of people change lawyers.
Next lawyer and the next lawyer and the next. So before we start to talk, let me show you this.
Yes. So I guess that there are some positives that hopefully maybe you don't have to wait till final trial for all the truth to come out. Hopefully maybe you can use your great documentation skills and just send it all across and say, hey, this is what they've said in the past. Here's all the proof.
If anyone ever asked my opinion about how the law could change to accommodate these things, I do think that the limit on pages is unfair to the person trying to rebut the lies, right? And I'm wondering if the court couldn't allow 10 pages for your own story and then a further 10 to refute the other affidavit. And then the other person who filed the first one can file one further 10 pages just to refute yours. So then you've got both sides of the story, because the court has this touching idea that people will be almost exactly the same because the truth's the truth, right? But it's not.
The whole point you're in court is because they're poopy bums.
And also, too, the concept of a person doing all of this and still be coping emotionally with the breakdown of a marriage and ongoing abuse, it seems. We are so unreasonable to expect people to function normally. And sometimes it's very cathartic to put your words down about. You always feel better when you get to respond to it in your affidavit. But if a lawyer says to you, we can't, it's a brief thing, we reserve the right, then you don't have your side of the story recorded and in there. So therapeutic jurisprudence is something that established in America, which I tried to practice, and that is that the client has to feel heard. And I think the court has to let people feel heard, and they have to let them put down in writing their response to all of this rubbish. And even though I know no one ever reads it again, and I know that the judges are mostly like, oh, yeah, here we go again, I've seen this story before. Every now and then there's a doubt in the client's mind that the judge brought an open mind to the case without hearing their side of the story. Just putting it out there, if anyone wants to know, that's my take on it.
And I think, Mum, we could just be saying to anyone who's listening to this today, congratulations to you.
Yes.
For one, you're listening to this, you're doing something about it. Two, you probably are still doing what you need to do and parenting if you need to parent, working if you need to work, whilst basically feeling like you're in a war zone, fighting this propaganda war.
With kids playing up, no doubt, because you're not functioning best.
Yes. And then you get sent a letter and you're just like, ugh. Or you get an affidavit and you're just like, oh, and you know, if you're halfway through this, you already know how much energy it's going to take you. So I cannot stress enough to be as organized as you can, which sounds ridiculous when you're going through this, but as organized and documenty as you can, and really, really take care of your space. Create a space for you, for your kids, for your family, for your friends, your loved ones, that does not let this crap in. Just have a little safe space.
And of course, the person who's a narcissist doesn't want you to have that. So they send a triple F letter, I call them. It's an ancient term I've just made up. 5 to 5 on Friday. 5 to 5 on Friday, you get a big, massive bombardment. Now, as a lawyer, I would never send that because I knew that I'd send it on Monday, because what good's it going to do you if I flip the letter over to you? You're stressed all weekend, and that's what the narcissist wants. So, yes, if you get a triple F letter, try not to read it until Monday.
As long as you've got the kids and there's nothing that you can get in trouble for.
Someone else to read it, see if there's anything risky in it, or, if it's meant to upset you, then it may well. I mean, I look forward to the day these sort of letters are called out in court.
I do too, Mother. I also want to point out to anyone listening today, because obviously not everyone, if you listen, you're not finished your final trial if you're listening to this. So everyone's somewhere on that conveyor belt. And if you'd like to know what the court system looks like, we've got a court conveyor belt episode you can listen to. But the one thing I've noticed about our members and our listeners as they go through from start to finish is they do get a second wind. They do get more energy and they become more empowered and they feel like a different person. Because it could take, when you're facing these kind of people, it can take 2, 3, 4 years. Don't think you're going to feel this horrible for the whole time, because you're going to get to a point where you have refuted some of their crap. You have got, maybe their lawyers kicked them out. Maybe they've had to get a different lawyer. Maybe they've got their bottom smacked by the judicial registrar. Something's going to happen to give you a little bit of, oh, okay, I can do this. So you are somewhere along the way going to get that feeling of empowerment. It is going to come to you and you are going to get stronger as you go through these battles. Yeah. So don't feel disheartened to think if you're at the beginning or just at the start that somehow you're going to be this feeling of overwhelming over you the whole time. I promise you, it's like exercise or going to a gym. Eventually you'll become like a little mini lawyer yourself and you will be kicking it to them, particularly if they're doing ridiculously provable lies.
Yeah. And Laura, I think we might make it Laura's law, but the longer you're away from a jerk, an awful person, the better you're able to cope. So even if you don't have any of those victories in court, time will allow you to look back and go, well, excuse me, that wasn't appropriate. What was I thinking? I wouldn't stand for that.
That's so true. That's what we've noticed with so many of the ladies and men, that the further away and the longer they've been away from these people, their attitude changes. And we have talked about the DV pendulum swing, where sometimes it can go a little bit too far the other way. But, as long as you're aware, and the best things you can do to help you boost that, like I said, is go see psychologists as well as a lawyer. Go and spend time with friends where you're not talking about this sort of stuff. But I cannot stress enough that putting documentation down and having one document that you can just print out and send off to anybody who asks. Staying with the police, and we've talked about the ARC app before and the Empower You app by the New South Wales Police. Both of those make it very easy to document on the spot while you're there. You can take a video recording, you can take a photo. It tells you the date, it tells you the time, put it all in. And you will feel better when you can just press print and you don't have to go scurrying around trying to chase your tail with these ridiculous lies.
I love that.
All right. So wishing everybody a happy beginning of the 2025. I promise you, if you're at the start of your journey, you're not going to know yourself at the end of 2025. So I hope that everybody listening today takes that little bit of hope away with them today. And Brandolini's law, just keep that in mind when all this nonsense starts coming out, and maybe you could go learn a little bit more about it. But go and see a lawyer, because you need to know what to refute and what not to bother with. And like Mum said, if you don't refute it, then unfortunately sometimes it can be taken as fact. So go and listen to our episode on how to read a letter like a lawyer, and our word salad episode as well.
Go and get legal advice. Yeah.
And you can actually download our 7-step checklist for that word salad letter off our website. So you just go to thedivorcecourse.com.au and you go to the free resources section. We've got mediation checklists, we've got before you go checklists, and we've got the word salad, read it like a lawyer letter.
It's quite popular, isn't it?
Yes, it is. It is. Go and check out all our other Narcissist episodes. Turns out one of our Narcissist episodes, Mind Over Manipulation, the Grey Rock episode, was actually our most popular on Spotify last year. So if you haven't listened to that, go and listen to that one as well. But Mum, again, thank you. Thank you for agreeing to do more podcasting this year.
As if I'd stopped.
And thank you to all our listeners, and we look forward to working with you all again in 2025.
Bye-bye, everyone. Good luck. Bye, Laura.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording